Good morning, Ruth and Anthony.
Good morning.
Good morning. Welcome to this session. Others are going to join us. Today is maybe it's a Sunday.
Yes.
But we must continue. So,
Okay.
We are going to start with the first question in October 2022. Which you can mute.
Okay.
Mute yourself. Which we had not tackled yesterday, which was question 1A. Then we go to March 2023. So let's start with the word of prayer. Father, we thank you, Lord, for this day. Thank you, God, for yet another opportunity we have, God, to tackle commercial. Give us wisdom. Let this technology, Zoom work. We pray, God, for Anthony. We pray for us, for Ruth. We do pray for others. And remember them as they prepare for their commercial exam. Let them pass. We pray in Jesus' matchless name. Amen.
Amen.
So, the question was going as follows. Vaseda Salt Company Limited is a salt making company based in East Kenya region, where it controls a large portion of market share. In its most recent strategic plan, the shareholders approved the expansion of the business to cover, for the first time, the Western Kenya market in order to improve on its profit. The market share in Western Kenya region is currently dominated by Mazobo Salt Company Limited. After many years of unsuccessful try to break into the Western market, Kenya market, Fazenda Salt Limited has been advised to enlist support of local distributors. Draft a standard distribution agreement that the company could use to approach local distributors for purposes of the penetrating of the market. So this is 5 marks. And I told you when you are told to draft a question of, we identified that this is a standard distribution agreement. You are told to draft, those are 5 marks. So you should not use a lot of time. This is a question to do with the recommended time of about 13 minutes. You should not use, you should not say so many things because it's a question of 5 marks. You identify the parties. That is the first thing, of course. You identify the parties, which is Fazenda and the Kenyan local distributors, but we have not been told the name. I'm looking at what Ruth sent me through WhatsApp. Of course, the appointment. It is another key clause, which you say that the Vessad Salt Company appoint this dash. Don't say its name because you are not being told. It is going to be filled with hard to be a local distributor on the following terms: relation between the parties. That is not so important, because it's a question of 5 marks. You can also say another key clause. You can say for this, of course, is the duration. That is a very key other key term, clause 5, what Ruth did. Then, of course, we must talk about consideration. Consideration, very, very important. Then you talk about breach, because a breach is another key component. Then then the termination. In breach, you can also include the whether you go to, if case of breach where you go to arbitration or go court. Then the other key clause is that of course you must talk about the termination. Termination of the how this distribution agreement will come to an end. Then after that, you don't need to talk about the jurisdiction. Then very, very important is the signature part. And of course, this is a company, so the director the directors of the companies would sign on behalf of the vessel sold company and the record distributor you are going to identify. So that is it, and you earn your 5 marks. So we are going to go to the next to March. Now we are going to enter into March. March 2023. I have to share the screen. Now they are before we start, yesterday there are things I discovered when I was preparing for this class, which I need to say, which are very, very important if you want to do well in your commercial exams or to pass. One of the things that I discovered is that, of course, I told you that this curriculum, commercial curriculum, was revised in 2019. So they removed chattels, they removed hire purchase, they removed other things there because it was very wrong. And then they now came up with these topics, which now the people, they started teaching in 2020. So the people in KSL, of course, 2023 are the fourth lot to be taught the new curriculum in commercial, 2020, 2021, 2022, 2023. Then these are the 8 topics which are tested. They are companies. I'm just recapping what I said yesterday because this is very, very important. Companies, which is a substantive law, then they ask you about the insolvency of company, both for natural person, which is called bankruptcy, or insolvency of company, which is called liquidation. Then partnership, and here you are looking at general partnership and LLPs. Then you come to mergers and acquisition, financial and payment systems, commercial agreements. Here there is joint venture, distributorship, franchise, guarantee, trust deeds, then movable property, security and security rights, then tax procedures in commercial. Those are 8 topics. So those big 8 topics, they started testing them in June 2021. Then there is the sitting of November 2021, April 2022, October 2022, March 2023. Now we are going to the 6th testing, which is now November 2023. Now, if you look at June 2021, all the topics were tested except financial and payment systems topic. When you go to November 2021, they did not test companies, partnerships, financial and payment system, and commercial agreements. In April 2022, they did not test movable property and security rights topic. In October 2022, all the other topics were tested except tax procedures in commercial law. Then, in March 2023, which we are now going to handle, they did not test financial and payment systems. So, if you look at that analysis, it will tell you something. It will tell you the following, that it will tell you that tax procedures, financial system and payment system topic, movable property security topic, and tax procedures are changed. That they are changed. If they test this time this topic, they test the other topic the other time. So essentially means that if you are to look at, you predict, if we can predict for November 2023 exams, I can say that mergers and acquisition will come as companies. Let's start with the companies. Both the substantive law and the insolvency part will come as those are 2 questions that must be tested, which those are 20 marks. Then mergers and acquisition, that is another very compulsory. That's a compulsory question that will be asked. Then those are 30 marks. Then commercial agreements. Now drafting has come back. It is another compulsory question. It will come. Then, number 5, those are 40 marks. Another compulsory question that will come is partnership. Partnership will come. Then, the 6th question, which will come, they will ask you either, because this time in March 2023, they ask about tax procedures. Most likely, they are going to ask about financial systems and financial and payment systems. Of course, that does not mean you don't read the other topics, but emphasis on emphasis number 1 is companies, the substantive law and the insolvency. That one must come 20 marks. In fact, it may become a compulsory question. And they will have different areas because it's a very huge area. If you look at the Companies Act and the Insolvency Act and the regulation therein. Then, mergers and acquisitions. That is another very difficult topic and emerging topic. That one, I can assure you, it will come. Then, those 3 questions, I can tell you, those are compulsory questions. They must come. The other 30 marks, in order for priority, I've still talked about partnership and commercial. Then, financial systems and movable properties. So that is a very interesting discovery that I made yesterday. And then we can go to our question now. Question 1. I want to read. Alpha Kenya Company Limited is a private non-listed company incorporated in Kenya with 2 main business operations, that is mining and shipping and manufacturing of mining and shipping machinery and equipment. Alpha is in the process of considering whether or not to undertake a restructuring program. Alpha annual turnover is $12 million. 5 Alpha members of the board of directors who own 60% of equity share capital in total hold the view that the restructuring program would not only simplify the company's structure, but would most likely become a tool of raising extra funds for expansion of mining and shipping business. According to these members, a few years after implementation of the proposed restructuring program, a reverse takeover should be undertaken to obtain a listing on the Nairobi Stock Exchange in order to raise new finances. However, the other 4 members of Alpha Board of Directors who own 40% of equity share capital in total have raised doubts about the restructuring program and reverse takeover, and are of the opinion that the company should either join hands or purchase 1 or 2 foreign corporate entities. Idaba Mining Limited, a Ugandan company that is the market leader in manufacturing equipment for mining sector in Uganda, or Ethiopia Shipping Services, that holds 40% of the local market share in Ethiopia shipping industry. Both foreign entities seem to be very attractive for acquisition. This is because Idabas mining annual turnover in the common market amounts to that money, 10.2 million US dollars, and company has its subsidiaries in Rwanda and Egypt, with export revenues of US $5 million for both countries. The Ethiopia's company annual turnover in the common market amounts to 10 US dollars, and the company has two subsidiaries, one in Mauritius and the other one is Seychelles, which accrue sales in excess of 5 billion pounds. Such expansion, according to the 4 members of AFA boards, will have a huge regional impact. Now, question 1A1. Should Alpha company remain to proceed to negotiate with a merger with one of the foreign entities? Typically, what documents would the company be expected to execute during the initial preparatory stage of merger and acquisition, M&A transaction, noted to express the general content? So, I've read the question for you. Today, Nani is not there. Kelly has not joined us. This is going to join us later. So we are going to follow the order that we are using yesterday. We start with you, Ruth. What do you think are the keywords there? When you are looking at that question, what are the keywords?
I would say negotiation, which is matters obviously, and the documents which the company requires.
The keywords there are initial preparatory stage of the merger and the documents. So what are the documents that are used in preparatory stage of a merger and acquisition? That is what, and you explain them. That is what this question is testing. So, what do you think, Anthony?
The documents are letter of intention for the takeover, for the merger, sorry.
Yes, can you explain the letter of Nini? The letter of intention.
Okay, I'll try. Yeah, the letter of intention will state the intention of the company to approach to purchase or take over the company, and also the matters of negotiation in terms of minutes and the resolution. And the commitment as well, the commitment for the transaction.
What do you think? The letter of intent is one of them. What do you think, Marianne, is another document that it is in this preparatory stage?
The other document that you need is the non-disclosure agreement. or the confidentiality agreement, which is basically to ensure confidentiality and information doesn't spill out. The other document I think you might use is the exclusivity agreement, whereby you tell them you're only dealing with us and you're receiving no other offers from us.
Yes, that is another document. Then the other document is called term sheet. Term sheet, which is the general terms. It sets out the general terms of mergers and acquisition prior to the preparation of the underlying agreement. Of course, Kerry has talked about the non-disclosure agreement. No, Marianne has talked about non-disclosure agreement. Then there is the letter of intent, which is called also memorandum. Memorandum of understanding, which documents the key terms and structure of contemplated transaction before committing the resources necessary to negotiate final points. Key terms, also called memorandum of understanding. Key terms, structure of contemplated transaction before committing the resources necessary to negotiate. We remember yesterday we dealt with the question of merger, also question 1. Now we are talking about the regulatory framework. Remember question 1 where we are nini. So these are this mergers and acquisition is, I can tell you, is not it's not easy area, but you have no choice but to prepare well, because it will come as it will come, very definitely it will come. It has been tested in the past in all the papers from June, and it will be tested again. Also investigate the following. This is a question that have not been tested in this area, but it might come. Now I'm giving you a link. I'm looking at, we are looking now at the future. Because when you are looking at the Q&A, we don't only look at the past, what have been tested. We also can predict to look at the future, what it must be tested, what must be tested, it might be tested. Process of merger and acquisition. Go and that is your homework. The documents have been tested. Go and internalize the process of merger and acquisition. It might come. And also drafting a merger and acquisition agreement. That one also has not been tested. It might come. And I said that yesterday. So we go to the next question. Advise Alpha Company Limited on jurisdictional threshold of notification of M&A transaction, explaining whether there are any exceptional circumstances in which Alpha Company Limited be exempted from notification requirement. What are the keywords there, Ruth?
I would say exemptional circumstances. And jurisdiction threshold.
The most keywords there are jurisdictional threshold, and exemption, exempted from notification requirement. Remember also yesterday or the other day, yes, yesterday, we dealt with exemption where also was in question 1. You see, this exemption thing has been repeated again. But of course they're asking different things. Where company merge and they are not supposed to be involved themselves in restrictive trades, but they can apply for exemption. Remember the section we looked at in the Competition Act, section 23, 25, 26. Those are very key sections. So, what do you think, Anthony? Make an attempt.
Come again?
Make an attempt in that question.
I think the threshold for notification is notifying the commission within 30 days. Within 30 days of, from the time they decide to propose the merger. If I'm not wrong. So there must be a notification. You must notify the commission.
This question, no, that is not the answer. This question is asking about the jurisdiction or the thresholds. The jurisdictional. What do you, when you ask about jurisdiction, threshold of jurisdiction? What? No, what is the meaning of the word jurisdiction to you in civil litigation?
Within a geographical boundary.
Yes, or it can be geographical boundary, or yes, it can be geographical boundaries, or legal threshold, or yeah, you know what I mean when, for example, when they say the court does not have jurisdiction.
Yeah.
Then there is exemption for notification. So what do you think, Marianne?
So I can't remember the specific instances, but like I think the threshold for notifying the commission is usually where the merger or the takeover would, first of all, it has to operate in, I think, at least at least 2 of the member states for COMESA. And then the other thing is that the merger itself will have like a regional impact, like either in the industry or like in the industry in the region. And then the third one is usually there has to be like a threshold for the combined turnover. I think it's like 1 billion shillings. I can't remember. So I think that's the first part, the jurisdictional threshold. And then where there are exemptions, circumstances to notify, I'm not sure, but there are usually two instances provided for, I think, in the Act, where one, you cannot notify at all when it's usually, but that means it's usually a very more of a smaller transaction where it will not reach the threshold, like maybe it's only happening in one state, or it's not adverse, it's not seriously impacting the industry, or it has a low turnover. Or two, there are those that have to notify, but then have permission to seek the exemption. So those are the ones that have a big impact and a big turnover, but because maybe like the oil and gas industry, because of the industry they're in and the way the Act wants to promote growth in those specific industries, especially for the then you're exempted from the notification requirements.
Yes. Yes. Miriam has done a very good attempt to explain the question. Now, on top of what Miriam have said, you said also you add the following as part of the answer. Remember, these are 6 marks. The Competition Act give the Competition Authority extraterritorial application and will apply to companies' activities within or outside Kenya. Incorporated in Kenya or carrying business in Kenya. And one on of course they need this alpha because it's want to enter into merger and acquisition with these foreign companies, which have been the Ugandan one. They are considering Ugandan one, Rwanda. They have subsidiary Mauritania. So of course, they are going to apply to Competition Authority, and the Competition Authority will consider whether the merger has a significant presence in Kenya, as evidenced by turnover or assets in Kenya of the acquiring or merging company, revenue generated in Kenya. Then those are the jurisdictional issues. When you come to exemption, the exemption which are exempted, mergers which are exempted, where the combined turnover of the merging parties does not exceed 500 million. And of course, this question, if you look at of course, this turnover of these companies is more than this. So they will not, your answer will be that they will not be exempted to from notification. They will not be exempted because the turnover is more than 500 billion. So they need to notify the competition authority. So my homework to you is go and you remember the question we tackled yesterday on exemption in restrictive trades, and now the exemption for notification. Go and fine tune on to this area, because if you see a question being repeated on an area, it usually means that the student have not been able to answer the question well. And because I told you mergers and acquisition is a compulsory question, it must come again. So go on and fine tune on this area of exemption, both in the question we tackled yesterday and this question. We go to the next question. What are the conditions that you have to be present should the board of directors of Alpha company decide to form a joint venture? So what is the keyword there, Ruth?
Oh, conditions and joint ventures.
Yes, the keyword there is joint venture. The keyword is joint venture. Remember also this we are dealing with joint venture in context of mergers and where it needs approval of competition authority. So what do you think, Anthony?
This one I don't know. I just have to pass the question.
Sorry?
I don't know the question. The answers.
Okay.
and the assistance.
Yesterday, in question 1, we dealt with question 1, October 2022. We dealt with also almost a similar question. Question 1B, October, where joint venture is where there is a merger and acquisition, and also joint venture can be said to be a merger. What do you think we said in that question yesterday? Kerry.
Sorry, I'm just getting psychologically into the class. Yeah, I'll answer the next one.
Okay. Marianne, what do you think?
Well, we dealt with the question yesterday. We were dealing with the documents for the joint venture.
Yes, we are doing with the document or regulatory. They have said yes, documents. Now here they're asking you they're asking you on conditions. What do you think?
Okay, first of all, I'll excuse myself and Kerry. We started this topic in class on Friday, and we've not reached here. But like for a joint venture, obviously there has to be the pool of resources together by you maybe another company. So they will have to be a schedule for distributing profits and losses. Then there'll have to be a minimum or maximum almost like guarantee for liability in the event something happens. I think those are the maybe in a joint venture, is there also the non-compete clause? I'm not sure, but like yes.
Okay. Yeah, so of course you are going to study it in class, and I don't think I may be wrong, but I don't think you are going to deal it very deeply, very deeply, where a joint venture constitutes a merger, because it's what the question is asking. I don't think you are going, and you are going to tell me when you in future. I don't think you are going to deal it very deep. So, because this is another area that is very difficult, you see now it was asked in October. Question 1 now has been asked again. Again, if you see a question that has been asked repeatedly, know that the question has not been captured. The student has not been able to be able to do well. So you need to go and tunasemaje, you go and you uende uive usome sana on this area. I'll refer to you to these guidelines are projected there, called the Competition Authority of Kenya Joint Venture Guidelines 2021. Go read the document. So,
pardon, you said you've done what? The document?
It's called Competition Authority of Kenya Joint Venture Guidelines 2021.
Okay, thank you.
When a joint venture constitutes a merger, in a question where there is a merger and acquisition, then they introduced a joint venture. So these are the things this is a document you need to know to go and study it. It will help you. And this question might come, it will come again. It might come again in November. So the conditions are, it needs to be a full faction joint venture. And a full faction joint venture is a joint venture that constitutes a merger within the meaning of Section 41 of the Competition Act. This means that the joint venture must be for a long duration of more than 10 years. With renewal provisions and all the function of existing or new autonomous economic entity which meets the following criteria, among others. Operating a market and performing the function numerically done by the undertakings, operating in relevant market, having a management dedicated to day-to-day operation and access to resources include, but not limited to finance, staff, and asset. The provision of management or advisory services. Liquidity rights and access of confidential information. The joint venture entity must have activities that go beyond one specific function of the parent company. Then does not wholly rely on purchase or supply agreements between its parents. And they have given there an example of an organogram. So this is page 5 and 6 of the Competition Authority of Kenya Joint Venture Guidelines in 2021. So my homework for you is that go and for those who are studying there in class, be very keen on this area, because this question it will come again, mergers and acquisition, and it will be a compulsory question. Read and reread again. It may come as a compulsory question. That means you will not be able to avoid it. It was a compulsory question in October 2022. Now it's a compulsory question. It might also come as a compulsory question again. And you need to be prepared. Very well. Look at the past areas which have been asked. Beyond October, going back, the areas also which have been asked here in the Q&A, and build your knowledge. I will go to the next question. You represent Nawira PLC, a client of many years. Mohatia, the Chief Executive Officer of Nawira, recently came to your office and indicated that Nawira has been in talks with Tajira PLC concerning a possible acquisition of Tarija by Nawira. Mohatia further indicated that Nawiri and Tajira in the agreement that the proposed transaction makes commercial sense and would be progressed to its conclusion. Tarija has shared a letter of intent with Nawira, and Mohatia indicating that the content in the letter of intent actually reflects the primary discussion between the two firms. Nawira's board is very keen in signing the letter as good faith gesture to facilitate further negotiation and due diligence. Mohatia has sought your legal advice on wisdom or otherwise of agreeing on the letter of intent, having heard from various sources that letters of intent have both risks and factors. Advise Mohatia on the risk and benefits of parties agreeing to the letters of intent and whether Nawira should proceed to draft. So, Mohatia is the chief CEO of Nawira. And Tajira want to acquire Nawira. Tajira PC acquire Nawira. So, of course, the first document we say that in question 1A here, A1, we said one of the document that is signed at pre-contract or the pre-stage, preparatory stage is letter of intent, or called a memorandum of understanding between those people, the acquiring and the acquiring entity and the entity that is going to be acquired. So, of course, the keyword there is letter of intent, and we defined it in question here, question 1A1. So you don't need to repeat it, to repeat the definition. So you go direct to the risk and benefits of letter of intent, also called a memorandum of understanding. So, Ruth, what do you think?
Oh, sorry. The letter of intent or the memorandum is just like an offer. It's not like something that you can, it's not binding. That is why you can accept it or not, and then later on you start drafting. It's just more of an offer. I'm just telling you that I want to merge with your company, and this is what I bring to the table. So once you agree, I might have oversold myself, but that is where you have to do the due diligence thing, the financial, the legal, and there's a third one, administrative functions and everything like that. And they deal with how, whether your cultural organization will match with mine. So, yes.
So you have said many things, but this question is asking you the risk and benefits. So one of the risks is that it may not be binding. That is a point, because it's a letter of intent. Another point, Anthony, risk or benefits of letter of intent.
Yes, besides it being not being a binding document, the members can rethink on the matters of the letter of intent. Sorry. So it gives them time to rethink as they look on the draft.
After they said good trial. Sorry?
I think they can decide and rethink of them agreeing on the letter of intention or revoking.
Good trial. Kerry?
Sorry, just come back to me later. I'm a bit distracted. Yeah.
Okay. Marianne, what do you think? Risk and benefits of a letter of intent, also called a memorandum of understanding?
The risk is, okay, one of the other benefits is that it also provides maybe for like confidentiality, so that this in on both sides, so that so that information doesn't spill out. The other benefit also for the party in proposing is that it provides maybe like a condition for exclusivity. So it puts that obligation on the other party where they are not receiving offers from other parties. On disadvantages, I keep wondering, can the what have okay, I don't know about the downfalls of letter of intent.
Okay. Now, so one of the benefits is that after they sign, the parties sign, the parties can know the viability of the deal early in the process. Which confirms that there are no unexpected deal breakers or glaring issues that could potentially derail the deal. I'll take that again. It allows parties knows the viability of the deal early in the process to confirm whether there are no unexpected deal breakers or glaring issues that could potentially derail the process. Another point is it avoids misrepresentations and discourages the negotiations of key points. So another benefit is that, which Mariana has alluded to, is that the binding exclusivity clause gives the potential buyer assurance during negotiation that the seller or acquiring entity won't use the offer as leverage to negotiate or sell the business to another buyer. Remember, this is a question of 5 marks. So those are enough risk benefits. The risks are the parties only have limited information about each other. So, and they have not committed time and resources to in-depth due diligence. So some of the most proposed terms in the letter of intent, like structure, purchase price, identification, costing condition, are generally non-binding. Ruth said that. I'll take that again. The parties only have limited information about each other and have not committed the time and resources to an in-depth due diligence analysis. Therefore, many proposed terms in the letter of intent, that is the structure, purchase price, identification, closing condition, are generally intended to be non-binding. Then another risk is that a poorly drafted letter of intent may fail to achieve potential benefit, thus creating animosity or distrust between the parties. So, you can proceed, Kerry.
Yeah, sorry, I wasn't able to talk earlier. So I was listening to like one of the risks, or is it a risk about some of the provisions not being binding, and then there's this other risk I was thinking about, like the possibility of the parties disclosing, but then now I think there's usually like the parties can sign an undisclosure agreement, so I believe that one can bind them, yeah. On top of on top, is it like on top of that, or during that process, so that they don't disclose what they've discussed? Yes. I think there was that point where we were saying that risk of them, the risk of them now using that information to negotiate with another or something of the sort.
You see, in a letter of intent,
okay.
There are clauses which are binding. For example, non-disclosure. Well, you can't disclose what you have discussed.
Okay.
With another person. Also, exclusivity clause. You are going to deal with for the time being. You are going to deal with each other, each other.
Okay.
But there are other non-binding clauses.
Okay.
Like purchase price. You have not done your due diligence. You have not you have not done many things. So you cannot set the purchase price at that at that time.
Okay.
So that is an unbinding. They are binding and unbinding clauses.
Okay. Okay. Good.
Sawa sawa.
Okay. Yes. Thank you.
So before now we go to question 2. My final submission to you on this topic of mergers and acquisition is that go and look at all the areas that have been tested in the Q&A, which I've already done. And there's something called with necessary modification, because some of the answers that I've given in the year 2008 to 2019 document are may not be the latest answers, because I did the research kitambo. So that's why I usually say that I usually indicate there the date when the research was done, and also the answer. So necessary modification, you modify the answer necessary, and then all the documents that we have stated, go and read them. Competition Act, general regulations, which we said yesterday, the guidelines given by CMA, be diligent in class, those who are doing this topic, and also know the merger and acquisition process that has not been tested, and drafting of an merger and acquisition. So by doing that, you'll be very ready to do this question. But if it is come as a choice question, that is question 2 to 6, the 10 marks, and you think you can do the others, avoid it. If you see that is like this is if this had come as a choice question, avoid this. But of course, there are things that you can do in mergers and acquisition. But of course, it may come as a compulsory. And if it comes a compulsory question and you don't have good answers, don't start with it. Start with another question that is going to give you confidence. Now we go to question 2. Question 2. Primary Limited is a limited company that is incorporated and has been registered office in South Africa. The company is desirous of setting up a branch in Kenya to carry out their watchmaking business. Due to your expertise on matters company law, the directors approached you in your offices to discuss how they may go about setting up their watchmaking business in Kenya. Advise them on the following aspects. The requirements of registering a foreign company branch in Kenya, 4 marks. So I'm going to start with Ruth. What is the topic that is being tested here? And what are the keywords? Ruth.
The topic is company law, the keyword foreign companies.
Yes.
Registering a foreign company.
Yes, registering a foreign company. Good. What do you think is the answer? I'm still on you.
Let me pass. I'm not well read in company law.
Yeah. Okay. Anthony, what do you think?
Yeah, they need to have they need to come up with their own memorandum and article of association in the different laws.
Memorandum and articles of association. Another document
which will have all the details of the directors.
Yes, that is one of the document. Another document.
The address of the business.
Sorry? Yes. You know, when
I'm saying the copies of documents from. Yes.
The internet is
a bit shaky.
It's a bit shaky. I don't know if it is yours or it is mine. When you're talking about documents, of course, they are going to share the documents of incorporation in South Africa, here in Kenya. And when you're talking about foreign documents, when they come to Kenya, they must be notarized. Now, for any foreign document that is coming to Kenya must be notarized there in South Africa. And also, if it is a document that is in Kenya and you want to use it outside the country, it must also be notarized by a notary here in Kenya. Kerry, what do you think?
Come again.
I'm saying, when you are talking about foreign documents, you can hear me?
I can hear you, yes, I can hear you.
When you're talking about documents of incorporation in South Africa and they want to be registered a foreign branch in Kenya, you must say that memorandum of association must be notarized in South Africa to be used in Kenya. Unaona? By a notary, by a notary public. Then if it is a document in Kenya and it wants to be used in a common law in a country, another country outside, it must be notarized here. For it to be used in a foreign company, in a foreign country.
Is it authorized, is it authorized or not? Notary.
Yes, notarized. Notarized is the word.
Yes.
It is the word notarized. But notary public is the person, eh?
Notary. Oh yes. Oh, I thought authorized. Sorry.
And notarized. Notary public is an advocate of 5 years post-admission, authorized by Chief Justice to be a notary. Like me, I'm a notary already. Unaona?
Okay, good.
I usually sign documents to be used outside the country. So a notary public in South Africa needs to notarize those documents. Memorandum. So, Kerry, what is the other requirements?
So, in addition to those specific entity documents that have been listed, there are also several forms that need to be filled. These are provided for in the Companies Act and the, what is it called? The process itself is done through the business registration service, and some of these forms include now the application for registration as a foreign company. It's called the FC1. Also, there's also another form, which is a statement of registered foreign company for use of alternative name or the name for the company. FC2, the notice of residential address change or residential address of local representative of the foreign company. Yes, so at least those ones, although there are a couple of them. Yeah, thank you.
Yeah, so that question have been what Kerry have said. Sorry,
James, we can't see your screen. Oh,
yes.
okay, maybe it's an internet issue. It's gray on my end. Your screen is gray. Yeah.
Okay. Let me try to fix it. Give me a minute.
Yeah, now I can see.
Okay, you can see. So I think Kerry have said the requirements. Look at section 975 to 995. Of course, the application is through eCitizen account, BRS, which is also, it is in Citizen. The first form is application form.
Yeah. Oh, sorry.
Sorry?
No, go ahead.
The first form is application for registration of a foreign company. You don't need to say that. You don't need to say. You may not remember the form what it's called. So just say application for registration of a foreign company. You fill the completed form. Other documents required are a certified and an authorized copy of company's certificate of incorporation, a certified and an authorized copy of company's memorandum of association, article of association, what Anthony said. a list containing names and personal details of directors. Now, this certified or unauthorized and unauthorized memorandum executed by, on behalf of the companies, it must state that any directors who reside in Kenya are the members of local board of directors. Very, very important key there is that there is a certified and unauthorized memorandum executed by or on behalf of the company stating the powers of any Kenyan directors and members of a local board. Of course, the notice of company registered office. Both for the principal place in South Africa and the branch in Kenya. Then another key particulars or requirement is name and personal postal addresses of person resident in Kenya will be authorized to accept service, who will be being served by a company's document in Kenya. You must give particulars. Then another very, very important, a mechanism for appointment of liquidator of the foreign company in respect of its properties in Kenya. A mechanism for appointment of a liquidator of the foreign companies in its foreign company in respect of its property in Kenya. So this is a repeated question. It was asked in question 4, June A1, 2021. So someone who has read the Q&A diligently would have done that question very well. Those are 4 free marks. I don't see the reason why you should fail. Interrelated or interlinked to this question, you may ask the requirements to register a private company. This one have been tested. You may be asked requirement to register a company limited by guarantee. We touched on company limited with guarantee yesterday. The processes and the documents. You may be asked requirement to register, the requirement of the conversion of a private company to a public company. Before a company starts to trade as a public company, it must have some requirements. Go and investigate. That is a very fertile area in exams. So we go to the next question. In their discussion with you, the directors would like to know the details of different shares that are available in the issue in the company. We are new, Miriam. What do you think this the keywords there?
The different shares that are available to issue in the company.
Yeah, those are the keywords. So, what are the different shares?
So I think there are ordinary shares, the ones that really demarcate ownership and are used. You become a member of the company. Then kuna redeemable shares where at winding up utarudishiwa share capital yako. And then there are preferential shares where you get you have no voting rights, but you, on the order of priority, you're paid first in terms of profits, and during winding up, you're also considered like a secured creditor. Those are the ones I remember.
Good. You explained ordinary shares. You explained preferential shares. You explain the other type of shares are called, of course, you have talked about redeemable. There is a type of shares called deferred or founders or management shares. These are shares that are reserved for people who, the founders or the management of the company. They are reserved these kind of shares. Then there is another type of shares called employee shares. The company may say that they are giving shares to the employees, and these can only be purchased by the employees of the company. Equity Bank, in June this year, just the other day, they gave a certain percentage to their employees shares. I think go and look at that, you will see. That is an example. Go in your, you Google, you see. Equity Bank is an example. Those are employee shares. Good. That is not a very difficult question. We go to the next. The directors would like to further understand the need and process of disclosure and of the beneficial ownership of companies in Kenya. What are the keywords there, Ruth?
Need and process of disclosure.
The need a process of disclosure. But the keywords there is beneficial ownership. Beneficial ownership of companies. The need and the process of disclosure of beneficial ownership. Those are the keywords. So, what do you think, Ruth? I'm still on you on the beneficial ownership.
For company law, let me pass. I've not reversed it well.
Okay, Anthony?
My apologies, I'm also not well versed with this question.
Okay. That's why I usually that's why I usually tells you to prepare well in advance. Kerry, what do you think?
Okay, a lot of it was from, there was a lot of, I think there was some new regulations, was it last year? I think so. Was it? Yeah, I believe it was last year. So there was a lot of talk around it. So, okay, so okay, let me just explain it generally, probably. So it was, I believe okay, so because of the whole process of how registration is done and shareholding and all, there's really this feeling that one does not get to know who's the actual, like, what they call the beneficial owner, and this beneficial owner has certain holdings. So, for example, in Kenya, they talk of, I think, holding like 10% of the issued shares, or the voting rights, or having that right to maybe like remove or appoint directors, or having influence. And the reason why there was a lot of push for these beneficial owners disclosure, not just in Kenya, but I guess I think it was pushed from I don't know, ODCs at higher levels coming down, was issues around, I don't know, people having shell companies, money laundering, and so many other nefarious activities. So they would want to actually know, or issuers, or even the fact that maybe you have a limited liability company, they know, of course, people will hide behind there. So that was the reason for disclosure. And this disclosure, I remember when the announcement was made, they were supposed to give their names, their date of birth, their PIN registration number, their addresses. And there was this talk in the background that they would want to even what is it called, like do like a matrix and join, and they might have found that this beneficial owners actually own a couple of, like they run so many companies in the background, only that maybe they hide under the face of probably a shareholding of another company and such layers. But generally, that's my understanding of the reasons behind getting to understand who is this beneficial owner and who this beneficial owner is. Yeah, thank you.
Yes, that question you have answered it very clearly. Those are the 2 marks. Beneficial owner is a individual person other than the legal person, a corporate body. Who owns the company? Then there are these regulations. I want you to go and interact with them for a question in this area called the beneficial ownership regulation 2020. Then you can say that the company is not supposed to disclose its beneficial ownership unless it's required by the registrar of companies. Of course, that is why this regulation were passed, because of what Kerry have said. Many people controlling in so many companies, money laundering, people are not fighting for accountability purposes. Or you can be required to disclose the beneficial ownership by court order. Then the steps in filing of beneficial ownership information of the company with the registrar are, first of all, the company will first identify their beneficial owners. Remember, this is the legal person who owns the company. The company will then give notice to the person it has identified as being a beneficial owner, requiring them, the person, to provide the following information within 21 days. Full names, copy of ID, postal address, residential, PIN, telephone number. The date which the person became a beneficial owner. Then the company then prepare a form that contains the information within 30 days of preparing the form. Failure to submit the beneficial owners attracts a maximum fine of 500,000. And that's why when this regulation we are passed, the register of companies required, or they were given sometimes to do that, all the companies. And people did it. I think the system was jamming, they were added another time. And of course, you do through online eCitizen. And the people, all the people, all the companies directors did this, including myself, because I have a company. I remember we did this. So what I'll tell, because this is a new area, go and interact with these regulations. Beneficial ownership regulations. Read more. What we have just talked is, I've gone beyond what the question was asking for future purposes. I told you companies is a very huge area and a fertile ground for examiners. In fact, it's a compulsory question. You'll be asked either the substantive law or the insolvency of a natural person or a company. Kerry, proceed.
Yeah, James, I was just, I just wanted to just share a resource, even as you've been pointing out, for those who are still looking into, a lot, especially on this topic, the business registration service, they've really done a good job of very beautifully done guides with diagrams, with everything, and they've really summarized a lot of the notes, and one can, like, you really pick them up, and especially where they've done, like maybe a whole topic on registration on, say, LLP, they have 2 pages, actually 1 page where they've just summarized step by step. So I think that would be a good resource we could just have a look at.
Yes.
Yeah.
Yes. You see business registration service website. They have very good documents. In fact, I rely with those documents when I'm doing my research. BRS came. It was that act, Registration of Business Act, and all this the registration and all these things came for ease of business, to promote ease of business in Kenya. So these people usually prepare very summarized, as Kerry is saying, very good documents without many legal jargons. And in your studies, when you are looking at this topic, including movable rights, they register securities, including even partnership. They register partnership, including companies, insolvency. They are very good documents, manuals that have been there in the website. So as you are preparing your notes, Ruth, you said you have not studied this topic. Kindly go to that website. It is going to help you a lot. And you'll be very ready for the exams. Sawa sawa.